Good afternoon, everyone. Welcome back. This is our second training in our series to study for the board certification exam for juvenile board certification. With us today is Stephanie Zimmerman. I've known Stephanie for a very long time, and you're going to love her training today. I always enjoy hearing Stephanie train. She's very entertaining and very informative. If you don't know Stephanie, Stephanie wears a lot of hats at Children's Legal Services. She is their deputy director. She's a statewide director of appeals and director of legislative affairs for Children's Legal Services. So we do very much appreciate her being here today and lending her expertise to our training and to your board study. Stephanie's had a very impressive career, and we are really glad to have her in our business. She's clerked for the Second District Court of Appeals. She has done complex trial and appellate litigation at Carlton Fields. She is the past chair of the Florida Bar Juvenile Rules Committee. She is currently a member of the Florida Bar Appellate Court Rules Committee. And of course, Stephanie is board certified in appellate practice. So please give your attention to Stephanie as she talks to us today about making and changing placements of children in Chapter 39 proceedings.
Thank you all for attending this training. It is going to be a robust training because we're trying to fit in a lot of concepts within a short period of time. So please bear with me as we go. In order to make sure that we cover all the bases, we're going to ask that you put your questions in the chat, and then we'll come back to them at the end. So let's kick off. First, why do placements matter? So anybody that has had a moment to work within the child welfare system knows that removal from a family is a traumatic experience. And so because there is that trauma, what we want to do is limit how much additional trauma that child has to go forward in their life. So if you think about it, every single move that a child makes, there is this repeated loss and grief. And so if we have multiple changes for a child, what that does is it starts to, based on science, tell them that don't get attached. It's not going to last. Or in a worst case scenario, the child will think something's wrong with me. These people don't want to care for me. What am I doing? And as we do each one of those placement changes that results in each one of those forms of trauma, we create this ripple effect where it changes the entire dynamics of a child. It can change their personality in the form of they can have aggression, they can have anxiety, they can even regress. But also, a placement change also impacts their whole holistic view of their relationships with their family and friends, their relationships even with siblings, where they go to school, whether they're on the same soccer team. And so because there are so many components of a child's life that can be impacted by this, we take the approach that we need to strive for the first placement being the best placement. This is a unofficial motto that exists within Chapter 39 to ensure that we are doing intentional placement decisions to ameliorate or limit the times that we have to move a child. So Chapter 39 has us focus even more so particularly on our younger children. They have statutes that are built around, let's look at placement transitions for infants specifically and what we have to think about for infants. They also want to make sure that what we're doing is not moving children when they're in this stage between approximately 7 months and 2 years. They've identified that that is the period of time when they're at their most able to bond and form those secure attachments. And so disrupting them then will cause those secure attachments to not be able to be formed. So how do we get a first placement, best placement for our children so they do not experience these traumas? We are going to talk today about some general placement considerations that we start about that are an umbrella approach across the entire case. Then we are going to get into the specific stages of the case, including modifications of placements that come later. So let's talk about some of those general placement considerations. So 39.4021 is going to be one of our umbrella statutes to talk about that general guidance that we should use as we talk about placements all throughout a Chapter 39 case. So let's start with the big picture first. We want children to be in the most family-like setting that is possible. And we want that family-like setting to be able to be in as close proximity to the parents so we can meet the needs of the family. What does that mean in practice? It does not behoove us to have a child be removed in Tampa, Florida, where the parents live in Tampa, Florida, and be placed in Miami, Florida. We know right away that that is not close proximity. And so every time that there needs to be a visit, there would have to be some form of transport. So we should not be looking at Miami for a Tampa-based child. Let's start in Tampa. But also, when we look at those settings, let's not start with group homes. Let's start with a number of people that the children might know, and then family-based settings. And we're going to talk about some of those priorities in a moment. This statute does establish a list of priorities that descend in an order. Now, it is a priority. It is not a mandatory list because we have to walk through what is needed for each child, and we're going to talk about that. But as a general consideration, as we look for close proximity, family like home, we can't forget our siblings. So as we look through this, we need to have sibling groups placed together in the same placement whenever possible, assuming that it's in the best interest of each one of the particular children. So we could have two siblings, and it might be in the best interest of sibling A to be together, but if it's not in the best interest of sibling B to be together, we have to prioritize each child's individual best interest. So I want you to keep in mind as we go through the next couple stages, family-like setting, close proximity, and siblings, as we now transition into, let's talk about the priority of placements. So the list was first developed in statute in 2021. Now, was there a general guidance for practicing this? Yes. But now it is in statute, and it is something that we have to comply with at every phase of a case. So let's start first with, this is if a child has to be placed out of home. So obviously, if the child can be placed with the parent with whom they were living at the time of removal, that's where we're going to go to first. But if we can't have the child placed with that parent, we are going to start looking at this list. Now, the legislature created this list in 2021 because research showed that if you place a child with family, it reduces the trauma of being removed from their home because they're being placed with individuals that they know. They also found that research shows that if you place with family, it's less likely to result in placement disruptions. And it also enhances the prospects of finding that permanent family if the child cannot return home. So we start first with the non-offending parent. Now, this assumes that we are in a scenario where there was a parent who had custody, who the child was living with, and one parent was the cause of the removal and the other parent was not. Now, a lot of people take issue with the word non-offending. That is a word that has caused a little bit of controversy over the years. Please don't view this on the PowerPoint as being anything describing anybody as there's an offending parent and there's a criminal nature. It was just easier for the legislature to say it that way instead. The parent against whom there were no allegations at the time of the removal and did not contribute to the reasons that the child entered out of home care. That is a very long-winded way of saying what they have reduced to non-offending parent. Okay, next, if you do not have a parent that can take placement of the child, we are to look to relative caregivers. We're going to dive into who is a relative. After that, the next priority is going to be an adoptive parent of the child's sibling. Now, I think it's important for us to take note of how that priority is with the next one, because fictive kin with a close existing relationship to the child is premised upon the child knowing that individual. Number 3, the adoptive parent. There is no requirement in the statute that the child have an existing relationship with that adoptive parent. It actually doesn't even require that the child have an existing relationship with that sibling. But we are supposed to look there. Again, coming back to the umbrella, would being placed there be in the best interest of that particular child? We're going to go through what some of those best interest factors are. But if we find ourselves in a situation where we do not have a relative caregiver, we do not have an adoptive parent of a child, sibling, and we do not have a fictive kin, somebody who has that close relationship, now we're going to get into a non-relative caregiver who does not have an existing relationship. Finally, we come to our licensed placements. Okay, in order for us to get these placement priorities in the right kind of order, let's talk about who may fall into each one of these a little bit more. So let's start with our relatives. So our relatives are going to be those people who are directly related to us, whether it is by blood, by marriage, or by adoption. And what is unique about this statute is that the statute creates an express list. It states those items, that those people that are on the screen. It does not say including but not limited to. So if there is an individual who does not fall into one of those specified categories, whether it be by marriage, whether it be by adoption, then that individual is not a relative for purpose of Chapter 39. Now, this definition is very different than what people generally practice. So if you were on any kind of heritage website, everybody in your lineage is deemed to be a relative, whether that is a fifth cousin twice removed, or whether it is the great, 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 great grandparent. Those are all relatives as people generally know them to be. Those people are not relatives for the purpose of Chapter 39. So we have to look at that as a specific relationship to understand if they are a relative. Importantly, the statute actually expressly precludes an individual who some might be believed to be a relative, which is it states that relative does not include a step parent. Okay, we know specifically who our relatives are. They are these aunts and uncles and cousins and grandparents. Let's go to the next category. So we have fictive kin. So fictive kin are people who are not related in any way. They are not related by birth. They're not related by marriage. They're not related by adoption. But what's important about this category is they have that existing relationship with the child. And that is that relationship that existed before they ever came into care. That relationship creates that family-like feeling for the child. So when we have to think about our priority, if we can't go to another parent, we can't go to a relative, the idea that we're going to go to somebody that has that existing relationship is going to prevent the traumas because they're going to somebody whom they know. And that's why fictive kin has taken a higher priority to other people who are non-relatives. Let's shift to that for a moment. I want to say something though, as we shift. Every fictive kin caregiver is a non-relative placement, but not every non-relative placement is a fictive kin caregiver. Let's think about this. So fictive kin, every one of them are unrelated. That's what's going to get them into the non-relative. But let me go on to non-relative to show you why not every fictive kin, every non-relative is a fictive kin. In the definition of non-relative, it is focusing on somebody who is either not related in any way or they're outside of a certain degree of relation. So consanguinity is a concept of how far away are you from that person in your ancestry. And so it has the fifth degree. It has to be outside of the fifth degree. Now, here's a little trivia for you. The law creates a gap. So relatives and who is listed, grandmother, grandfather, great-grandparent, are all within the fourth degree. Non-relative says it's got to be somebody outside the fifth degree. So what do we do with people who are in the fifth degree? We have been treating them as non-relatives because there is no other category available. So while relatives gave us an express list that don't let us put anybody else in, non-relative definition is not so as express as to leave those people as being in no category at all. We also have to now bring in our step parents. So because step parents were expressly precluded from being relatives, The only category that remains for step parents are going to be our non-relative category. So if we think back to the priority, if the person is unrelated, but they have this great relationship, they are now fictive kin, and they're going to get a higher priority than if there is no relationship and they're a non-relative who is a stranger. You might say, who are you talking about? Why would we ever place with somebody if they have no relationship, no identifier? Let's think about the families as they come into these cases. When they come into these cases, we ask them who could potentially care for your child. We can have a situation where the mother has a long lost relative that's way outside the degrees, who she hasn't seen in 5 years, but she knows that that person's going to step up for them. She will offer that name. Now, that person has no relationship with the child, but it's somebody who the parent knows and the parent trusts and might support that parent on a pathway to reunification. So we will consider that person. Or what if it's a parent's coworker, a parent's member of a church, a parent's counselor? Any of those people would be non-relatives to the child because they're unrelated and they do not have that relationship to be the fictive kin. But we should prioritize it because they are known to the family in some way. Okay, let's talk about how we are going to find some of these placements. We're still under the general placements consideration as we work through this. So in 2021, the legislature incorporated a new statute, section 39.4015, to specifically talk about our family finding efforts. Let's keep in mind, first placement, best placement. How are we going to make sure that we get a child into a priority of placement that is going to support reunification, reduce the number of moves? We sometimes have to go find individuals. So there is now a requirement to engage in family finding efforts. This requirement is more than a basic internet search. We are supposed to do an intensive search for the family where we do interviews, we ask questions, and we try to search the databases that we have available to find individuals. Now, the goal here is not just placement. The goal here is to support a family. So we may very well find people who can provide that relative care, can provide that non-relative care. But more importantly, even if we can't find them, you have the chance here to find individuals who are going to support the family through perhaps attending family team counseling. They can support visits by being a supervisor of visits. They can assist in transportation, or perhaps they can provide respite, because no matter who the caregiver is, some of our caregivers need the opportunity to have that break where they can rely upon others, just like we would in a traditional family. So the family finding efforts are important to ensure that we are finding as many people to support the family and to support the placement. Okay, so we've talked about priority of placements that we have to observe and how we're going to find people to support that. The next general consideration that we need as we talk about placements is going to be the impact of siblings. We cannot talk about a placement without asking the question, is there a sibling? What is a sibling? So we've got two categories, and it didn't always used to be this way. Historically, there was only the first category, which were children who shared a birth parent or legal parent with one or more other children. But the legislature years ago said that's not good enough because science tells us that there are these categories of what are called psychological siblings. Those are children that have lived together in a family unit in such a way that they identify as the sibling. They call each other brother and sister, even if they're not biologically related, even if they're not legally related. Now, the psychological siblings can be children that had psychological siblings before the case ever started. But we also have psychological siblings actually developed during these cases. So when we have children that are placed together in the same family foster home or placed together with the same relatives, they start to develop and identify each other as brother and sister. And we have to keep that in mind as we go through the rest of the case. As we make that first placement, and as we make every placement change thereafter, we are mandated by Florida law to consider siblings. So why are we required to consider them? So the legislature has incorporated in Chapter 39 its legislative findings with respect to siblings. And so they have found that that relationship between siblings could be the most continuous lifelong relationship of a child. It could be their longest relationship with anybody. And because of that, they want them to be together because continuing to share those relationships grows that child in their own strengths, their experiences, and it can give them a protective factor as they work through. So knowing how important it is to support our siblings, what does the department need to do as we evaluate those sibling relationships and placements? We start first with the premise of, is it in the best interest of each child to be placed together? So we have a mandate to place together whenever it is in the best interest of each child to be placed together. So we should make reasonable efforts to keep siblings together in the same home when a joint placement is available. So 2 children come in at the same time. There's a home available that will take both children. It's safe for both children. It's in the best interest of both children. Keep them together. But what if we have siblings come in and we have 2 relative caregivers? We have an aunt and we have a second aunt. And based upon their living conditions, they can only take 1 child each. It may be in the best interest of those children to have 1 child placed with 1 aunt and 1 child placed with the other aunt. However, if we examine the sibling relationship, it also could be in the best interest of the children to be together and instead stay with a fictive kin. Maybe there's a best friend of the parent. We can't view it in a vacuum of we must always do relative priority over others so that the kids get separated. We can't always say that the kids have to be together in every instance. It requires an examination of what does the relationship look like? What is the appropriateness and capability of the caregivers? Now that's talking about when they come in together. Let's talk about when they don't come in together. So there's children that come in to care, and then there's children that come in later. Now they can come in later for various reasons. For example, perhaps they were not the subject of abuse at the time. Perhaps they were living with a different parent and maybe that parent's placement has now collapsed, or perhaps they were born later. The law tells us if they enter out of home care later than their sibling, we are to make those reasonable efforts to place them together. So our first stop should be going to the siblings placement and saying, is there capacity? Can you take another child? But if that placement says, I don't have the capacity, I do not have the means, and actually, if I were to take 2, I would have to disrupt this placement to do it, we are not required to jeopardize that first sibling's placement who has been in care in order to try to place another sibling with them. So that's not we're not required to jeopardize placements. There's also another piece that we're not required to do. So the department and the court are not required to make a change of placement to develop relationships with siblings that did not exist. Now, we all have to tread lightly with this one. This is not a carte blanche, don't try. The legislature has said, make reasonable efforts to place children together. But the legislature also, in this statute, has said that the team should prioritize existing healthy relationships between siblings that know each other, that have been raised together, prioritize those relationships different than relationships that have not yet been formed between siblings, but they have existing healthy bonds with caregivers. So we're not required to move a child to create a relationship that did not exist, but we are still in this posture of figuring out, should we try to move a child to unite them for the first time? And the legislature outlined for us some factors that we are to consider. So let's look at those factors. First factor is the quality of the current attachments of the children. And that itself has a number of sub-factors. So you have to look at where the children are and where they may be going. So if we talk about a situation where a child has been raised by an aunt since coming into out-of-home care, and that aunt can't take one more child because they're at capacity, and we're talking about moving to another aunt that that child knows, that is a very different conversation than we are talking about moving a child out of a home with an aunt to go into licensed foster care with a new person that they never met so that they can now be united with their sibling that they did not previously have an existing relationship. We're to handle that differently. We look at the ages too. So when we talk about infants, we have to have certain considerations that are very different than if we're talking about 16 and 17-year-olds. We also have to talk about from the age, how long have they been placed with individuals? How many moves have they already had? And as they've done those moves, what has been that history of attachment? So those are all the factors that we have to consider just under their current attachment. After we evaluate their current attachment, we need to move on to a couple other factors. And that includes the quality of those existing relationships and the potential to form the sibling relationships, those benefits, or maybe the cost of disrupting the placement. And if we can't place the siblings together, what is that opportunity to still develop and maintain those relationships despite it? It's a lot to consider with respect to siblings, many factors, where they were before they came in. Did they have a relationship? Do we have ability to form any relationship? So we have to walk through each one of those with siblings. So let's recap where we are right now. We're still under that general placement umbrella. There's a lot to take in. We talked about priority of placements. We talked about siblings, but there's one more thing I have to talk about before we go into the duration of the case, and that is the home where the child's going to be. So we got to talk about home study requirements. So the way that the process works is if a child has to come into care on an emergency basis, there has to be that emergency placement check first. And what that consists of is a name-based check of the criminal history. So aunt, uncle, cousin, counselor, soccer coach, they give us their name, and the Department of Children and Families does the criminal history check. That criminal history check is going to check whether they and any member of their household have what are called disqualifiers. Now, if they do, the court can review the department's decision based upon the information that criminal history check. So let's do a situation. Let's keep talking about this aunt. What if the aunt has a disqualifier, but has been rehabilitated since? While the department is not permitted to place, a court can say that that movement has demonstrated that rehabilitation, and the placement will be in the best interest because of that long-standing relationship with the aunt, the continuity that the aunt can provide, and the support that the aunt plans to provide to the mother and father as they work towards reunification. So I've talked about disqualifiers a little bit. Let's dig into them just really quickly so that you understand the two different categories. So category one is going to be what people have referred to of permanent disqualifiers, automatic disqualifiers, mandatory disqualifiers. They've used all of those misnomers. I like to call them permanent disqualifiers because whether they are in this long-term or whether it's a 5-year, they're both mandatory that the department cannot place. And so our permanent disqualifiers are if you have a conviction for any of these things, the department cannot place a child in the home. And so these are those crimes that are most commonly associated with safety risk to the child, because either they've involved children or they are of such a violent nature that there is a concern for anybody being placed in that home. So these mandatory, you have them, the department cannot place ever. We also have those that are temporary disqualifiers. So if you have felonies for these convictions that are on the screen, it's a pause button. For 5 years from that conviction, you cannot have a placement. So let's say we find with the aunt that she has a basic assault felony charge in her background. If it's from 1990, the pause button's off. There can be a placement. But if that conviction is from 2025, the pause button is pushed and the department can't place. Again, there's a process where a court can overcome it by finding that there's been rehabilitation. Let's assume that we have a caregiver who has no disqualifiers. We do that name-based check. The way that Chapter 39 is written is for the purposes of the shelter and the emergency placement, the department can place the child with that family while the rest of the home study is done. So that was a name-based check we place. We then go and do further examination. That includes actually doing fingerprints to back up that name-based check. But also, it really involves digging in deep to the home and the circumstances of the home. So we have to do a home study in which we do the interview of that aunt, that counselor, that soccer coach. We have to talk with them about what is their commitment to this child, this family. Got to look at the home, assess it, determine if they have plans for childcare if they're going to be out of the home. Now, of course, there's always some childcare vouchers that are available, but what are the plans? And we have to document this information. If after going through all the mandatory requirements, that home study is unfavorable, Chapter 39 requires that the department cannot place the child there, but instead the court can find it's in the best interest to be placed for whatever is in the child's best interest. So the department is prohibited from continuing that emergency placement if it's unfavorable, but the court can find it's in the child's best interest to do so nevertheless. Okay, we did our basic umbrella. We talked about priority placements. We talked about siblings. We talked about home studies. Now let's start working through the dependency case as it relates to each one of the milestones. What are we hitting on in placement? Shelter. All right, what happens at that first court hearing? So we talked earlier before about our placement priority. The department has to demonstrate at that shelter that it made reasonable efforts to place in that order of priority, or the department has to establish why it's in the child's best interest to not be placed in that priority. Let's keep on reasonable efforts. The department also has to make the reasonable efforts to keep the children together. These are things that the court is supposed to actively be finding at the shelter proceeding. Next, the court, in its order, is to direct that the department has placement and care responsibility for any child not placed with the parent. What does that mean? So that actually is a Title IV-E requirement. So Title IV-E is a federal mechanism by which the foster care system can be supported through federal funds as long as certain conditions are met. Those are families that are in needs and can establish a needs-based, but also there are various findings that have to be made by the court in order for foster care payments, adoptive payments, to be supported all throughout the duration of the case. And one of those findings is placement and care responsibility. That means that if the child is placed with relative, non-relative, it is the duty of the department to ensure the safety throughout the entire case as long as it has placement and care responsibility. So if the department learns that there's an issue, the department is supposed to alert the court. If we learn of an issue that is so grave as to abuse, abandonment, or neglect, we are to take action and assume that responsibility for the child. It basically means that the department all throughout the placement is not supposed to sit in the back seat and let the placement drive and just make sure everything's okay. We are supposed to be constantly monitoring, which includes our 30-day visits, to make sure that that child's safety and well-being are being cared for. Okay. Siblings, not only did we have a reasonable effort to place them together to demonstrate that, if we have to separate siblings at shelter, we are to make a recommendation for the visits and what that contact is supposed to look like. And that contact is supposed to start immediately. If that contact cannot happen within 72 hours, the department has got to explain why it can't happen within 72 hours. So think about this. You are growing up with your siblings and suddenly you are taken away from your parents, and then you also don't get to be with your siblings. The legislature put that 72 hours in place to make sure that there could be some form of continuity for the children, even if they could not immediately see their parents. And last, to support those family finding efforts, the court is to inquire of the parents whether there are any relatives available for placement. Let's figure out how we can support this family throughout the process. Now, that's what happens in the courtroom at shelter. Let's talk about what happens outside the courtroom. So outside the courtroom, we are supposed to also do a staffing that is called an MDT staffing. MDT standing for multidisciplinary team staffing. We're going to be digging into MDTs a bit more later. For now, here's what you need to know about the basic requirements. We can have that staffing before the initial placement. If we know that this is going to be a planned removal, we can have it before. But if we don't, because so many of our removals are an emergency process, we have to do it as soon as possible after the initial removal. And that purpose of that MDT is to ensure that that initial placement is as appropriate as possible, and we are anticipating and addressing any adjustments right there at the front end. First placement, best placement. Is this the right placement? And if it is not the right placement, resolve that now before attachments form. Now, while the legislature required that the first initial removal has to be as soon as possible, if there is going to be a subsequent removal, that has to be no less than 72 hours. So let's talk about some fact scenarios where this might break down. So if there is a removal from a mother, but placement with a father, we must do that first MDT as soon as possible. But then if a removal from that father is necessary now, that constitutes a subsequent removal. That MDT has to be held also again, now within a 72-hour period of time. So each time a child has to be removed from a home, we have to do an MDT. Now, we also are convening not just for the purpose of addressing the placement, but we also have to talk about the educational options here. At removal, we need to talk about, is this child going to have to change schools? Because the legislature in Chapter 39 has said that every effort should be made to keep a child in the school of origin if it's in the child's best interest to do so. If you can't, then that MDT, the first MDT, is supposed to be creating a transition plan for that school change. All right, shelter. What happens in the courtroom about best interest, about sibling placements, or visitation if they're not together. What happens outside the courtroom is MDT. We're going to have a lot of that continue throughout the case. Let's go to the next milestone, which is disposition. All right, so where we're at in the case is we had a shelter. We now, if we're at disposition, we're going to assume that we've had an adjudication of dependency. Now, the court at disposition, among all the many things it's supposed to be doing, is supposed to be determining the placement of a child. And so the dispositional statute 39.521 has a couple requirements as we work through it. Well, I've listed them in the order of the statute. They're not exactly listed in the order that follows kind of logic, because the very first reference is the court has to order the child into a placement. But we got to talk about what placements are available and what is that order and what is that priority. It also contemplates that we have to provide a home study for the proposed placement if it's going to be anything other than licensed care. That means a home study even if it's a child's being placed with the other parent. So, but for licensed, we know the court has to have a home study before they complete this placement, and we know that the court has to reduce that placement to writing in an order. But how do they determine the placement? So 39.521.3 starts walking through those. Now, it never says expressly this is a priority of placement in 521, but we have to remember 521 has to be read in conjunction with our priority of placement statute 39.4021. So it's listed in the following order. So first, can you place with the child, with the parent with whom the child was residing at the time of the events? You can't if it is safe to do so and it's in the best interest to do so. But if a child cannot safely remain in that home and it is not in their best interest, the next step is the parent that the child was not residing with at the time of the events. So the standard to be used for that is endangerment. So the legislature contemplated that we should try to place with that other parent unless there is endangerment to the child from doing so. Now, I've put a couple little asterisks on the screen to clarify a couple scenarios. So if we place with a parent who the child was residing at the time of shelter, that placement has to be in place for at least 6 months of supervision. But if we place with a parent that the child was not residing with at the time of shelter, this case can take two different paths. 39.521 3B allows the court to not just place with the other parent, but the court can terminate jurisdiction immediately. That would mean no case plan for the parent whose actions caused the removal. That would also mean that there's no further supervision by the department. This is very different than the 6 months that's required for the parent who contributed to the removal. So that's one pathway. Place with the other parent, close the case, no more dependency. But 3B also contemplates a different route. And it tends to be the more common route, which is the court can place with the parent and order the other parent to comply with reunification services. Now, once we get through the parents, we're going to come back to, okay, now we've got our relatives, we've got our adoptive parents and siblings and other adults. Now, 39.521 says other adult. That is going to capture both your fictive kin and your non-relatives. And the final category is the temporary legal custody of the department. That's going to be your licensed care, whether that's a licensed family foster home or whether that is going to be a group home. So as our courts process these, they layer it on top of the priority placements we talked about earlier. Let's go with the most family-like setting that we can to reduce the trauma. All right, so at disposition, it's contemplated that the place where we're going to place the child will be your long-term placement until reunification can be achieved. While that is the goal, that does not always happen. So we have to talk today about modification of placement. And that is where so much of the litigation does relate. Okay, what is a modification of placement? We got to understand what a placement change is. And there are a couple different definitions. So let's start with the very first one. 39.4022 is the statute that relates to when to do an MDT staffing. And that describes a change in physical custody as a change by the department or CBC to the child's physical residence, regardless of whether it requires a court order to change the legal custody. So let's look at that first definition and let's think about a caregiver for a moment. Let's have a caregiver that is living in an apartment in which everything's going great. And then the landlord suddenly says that the rent is going up $500 a month. That caregiver can no longer live in that apartment. But there's an apartment 1 block away that they can move to, that we can do a home study on, that can pass a home study, and that caregiver can take the children and everybody remain intact. Because though there is a change to the physical residential address, that is a change in placement for the purpose of an MDT. When we go to our change of placement post-disposition statute, which is 39.522, it uses the exact same definition. So we're not thinking about it solely in the context of MDTs. We're also talking about changes in physical custody for the purpose of modifications of placement. Now, there's another definition that's in 39, and that's in 39.4023. Now, this is our transition planning statute. And this contemplates that anytime a child is moved from one caregiver to another is when you have a change of placement. So our first scenario where we talked about a caregiver that has to move apartments, that's not a placement change under the transition statute, but it is under the MDT. So the one consistency we have sometimes in Chapter 39 is that we have inconsistency, and this is an example of one. So as we work through modifications of placement, we have to think about, is this a change in physical custody or is this a placement change in what is required for each one? So let's start first with the changes in physical custody, our first definition that requires an MDT. What are we going to do at those MDTs? So we've got a scenario. Let's keep with that scenario of we've got the caregiver that has to move homes just because the rent has gone up. Keep that person in mind as we talk about these requirements. So an MDT is a group of individuals who are going to come together, collaborate, and reach a consensus on what is that most suitable out-of-home placement. But when they do so, they also have to think about education, and they also have to think about, are there other major life decisions that are important that we need to talk about at that MDT? So the goal is to ensure the child's safety, and we're going to make sure that everybody has the opportunity to provide as much input as possible on that placement decision, or sometimes we're talking about a change, can we just maintain the current one? That's what's in the best interest of the child. How are these placement conversations we're having going to impact that family and the connections with the family? The child and the family have to remain the focus. So while there can be MDTs for a variety of reasons, because we're here today on placement changes, we're going to stick to placement change. So who attends an MDT for a placement change? Child, if they're of a sufficient age, child's family members and other people who are important to the child, both the current and the proposed caregiver, a representative from the department other than CLS when the department is involved in the goal, and a representative from the CBC when the CBC is involved in the goal, the case manager with supervisor and DJJ. Now, the first group of bullets there that do not have an asterisk are those people who must be invited. Must be invited. The statute's not written that they must attend. So if for whatever reason somebody that falls in that category can't attend, it is not going to prevent the MDT. But 394022, which is the MDT statute, does contemplate that there has to be reasonable notice of the MDT so that the people can attend. The last category is once we get past the people that must be invited, there is a category of individuals who can be invited. And those are the other individuals who are important in their lives, such as their therapist, or if they're receiving medical services through CMS, invite those individuals. So we got who must be invited. When are we going to have it? So when we have these planned moves, there is supposed to be 14 days notice before the proposed move. You give notice of the move, 14 days, you then convene the MDT. It's not written that the MDT has to be 14 days before. It's the notice has to be before. Next, we have scenarios where we don't always have planned moves. And if we don't have a planned move, but instead find ourselves in a situation where we have an emergency, then we have to convene the MDT within 72 hours. But an emergency is not in the eye of the beholder. An emergency has a very specific definition of there has to be that imminent risk to the health and safety of the child, other children in the home, or others in the home if the child remains there. So a lot of times when we talk about safety, we're talking about safety for the child, but what if that child is unsafe to other children in the home? That would also be an emergency situation. And there's finally a category that has some special protections, and that we're going to talk about a little bit longer about our long-term caregivers. But if there is a long-term caregiver, then that MDT needs to be 21 days before a planned move so that all of the process can be worked. All right, so we're bringing all these people. We have the must be invited. We also have the when are we going to do it? Now, what are they going to talk about? So they need to go through the factors that are called the best interest factors in 39.01375. So the statute 394022 specifically says go to the best interest statute and consider that. Now you can also consider assessments, therapist reports, visitation notes. You can consider the sky, the sun, the moon, the whole 9 yards, but start at least with these 15 factors. These are the factors that are going to apply to anybody who is but a parent. Parents have a different standard that we're going to talk about. These factors are very much soup to nuts. Many things. It's the current relationship. It's the preferences of everybody involved. We're going to get to the siblings, permanency, the receipt of services. We're even going to talk about the allegations of why the child came into care. The catch-all. And there's always a catch-all. Any other relevant factor, that is a signal to everybody. Talk about every single thing that you can. What is important to this child? Because if you're going to talk about a placement change, uprooting this child, discuss it all. Discuss it in depth. and figure out what really is in the best interest of the child. All right, so after considering all of these best interest factors about the placement change, now the MDT has to make a decision. So if a unanimous decision is reached, it becomes binding on if there was a department representative or CBC representative there, it will be binding on them. So let's say that there was a physical change of placement because that aunt had to move for rent. At the MDT, it was learned this change is like only 2 blocks down, and the child be able to attend the same school, have the exact same activities, would continue to have their court-ordered parent visitations with no disruption. So, decisions unanimous. Yes, that's a placement change, and we can move. Here's the catch. We don't need to actually go into court after that MDT decision. And that's because that court order for placement that happened in the disposition should have been for the temporary legal custody in the care of the aunt. And because there's no change of court order, we conduct the MDT, reach an unanimous decision, and that is the end of the conversation there. Okay, but let's talk about a different scenario. What if the child was currently living with a non-relative and now we're proposing a change to a relative? And that change is going to require a change of schools, but it would also reunite a child with a sibling that they had an existing relationship with before shelter. If anybody that attends votes no to the move, whether that is the current caregiver, the child themselves, then because we are talking about a move from a non-relative to a relative, we're going to have to invoke the rest of these factors. So if there's not a decision that's reached, the MDT facilitator is going to notify the court and the department within 48 hours. The statute contemplates then that the facilitator has to give a final report to the court within 5 business days on what is the final result. What is not actually listed in that statute is now the department has to make a decision. So between the 48 hours of the staffing with the notice and the 5 business days for filing the final report, the department has to review the information that was provided to the MDT and decide what is best for the child, examining those 15 best interest factors. Let's say that the department did that. And in this scenario where we're moving from a non-relative to a relative, decides it is in the child's best interest because of the relationships that they maybe had, the reunification with a sibling, the priority of placements. Now we're contemplating a move of the child that is going to require a change of legal custody. So now we got to go forward with a court hearing. Let's do a little recap. Okay. There must be an MDT whenever there's a proposed placement change. But not every MDT is going to result in an actual hearing. So you can not need a hearing because everybody agrees not to move the child. Maybe you came and yours a plan to move from non-relative to relative, but what if the complete unanimous consensus is let's not move right now? That ends the MDT and the conversation. Or what if there is a unanimous decision to move, but it's not going to change anything about the court order? The relative is just simply picking up the home and moving it down the street. We would need a hearing, though, if there is going to be a change in that legal custody status, whether that is moving out of foster care to a relative or non-relative, or whether it's moving between relative and non-relative. We also will be required to do a hearing anytime that a party or a long-term caregiver requests a hearing. So let's talk about those hearings real quick. So the statute is written in such a way that not just the department, any other interested person can bring a motion to modify anytime before the child is residing in a long-term or residing in a permanent placement. If any party denies the need, the court has to hear the parties. And when the court hears the parties, it is required to consider the best interest factors, the 15, the MDT report, and the priority of placements when it makes its best interest decision. Note, when we're talking about permanent placement, licensed care is not deemed to be a permanent placement because it is not with a specific custodian. So Let's talk about our long-term caregivers, because in 2021, there was a new concept created. Many people refer to it as the rebuttable presumption. And the legislature created a rebuttable presumption that a child should remain in their current home if all of these conditions are met. So we all start with 9 months. Start the clock is there have been 9 months where the child has been in that home consecutively. If you don't have the 9 months, it doesn't apply. Next, we look at is reunification the permanency option at the moment? Is the caregiver able, willing, and eligible? What we oftentimes have to look to besides the 9 months is this going to reunify the child with a parent? If it is, long-term caregivers don't get to have greater rights than our parents. And so there will be no rebuttable presumption. But also the legislature made a caveat that there will be no rebuttable presumption if this reunifies a child with a sibling. There's a final caveat that the rebuttable presumption does not apply if we are moving a child from a non-relative caregiver to a relative caregiver. Now, if you meet all these requirements, you're not moving to a parent, you're not moving to a sibling, you're not moving from non-relative to relative, you got 9 months, they're ready, willing, able, all of that. What does it do? Okay, when we have a rebuttable presumption, the department's position from that MDT has to be given to that caregiver within 5 business days. That caregiver now has 5 days of their own to notify the court of their objection and to request an evidentiary hearing. A lot of times I hear people come out of these hearings and meetings and say, well, they have a rebuttable presumption, so we're all going to court. The caregiver has to initiate that process and make the request for the evidentiary hearing in order for the rebuttable presumption and all of the processes to apply. During that 5 days where they have that opportunity to do the objection, child is not supposed to move. Case management cannot move the child until the expiration of the 5 days. But if the caregiver files that objection, now the child's not being moved without a court order. When you come in and now have the rebuttable presumption in place, the court has to conduct a status hearing within 7 days where now that long-term caregiver is going to be given party status that ends either in 90 days or upon the final order. They're notified of the right to retain counsel, and the court is to appoint a neutral child parent bonding expert to help the court reach this very important decision. Court's got 90 days. 90 days to come together to conduct the evidentiary hearing and to issue the order. And if there is a placement change, there has to be a transition plan like there is for every placement change. Okay, so as we walk through this, let's recap that placement changes that happen after disposition between caregivers, party, interested person can file that motion. Or if a long-term caregiver wants to object to that MDT decision, the court is going to need to conduct a hearing. At the hearing, we might have long-term caregivers elevated to party status if they meet all those conditions. If they meet all those conditions, the court's going to apply a rebuttable presumption. But at the end of the day, even if there is no rebuttable presumption, even if there was an immediate move, all of this comes back to there must always be the best interest of the child is driving the court's decision on these. All right, let's shift here to reunification with a parent. Now, 39.522 sets out very specific standards for different modifications of placement. And so to reunify a child with a parent when they have been living with somebody that is not the parent, we are to review the conditions for return and determine whether the circumstances that led to the child's removal have been remedied to the extent an in-home safety plan prepared by the department would not be detrimental to the child. So law changed. It used to be you had to substantially comply with the case plan to reunify. That is no longer the law. Now we're not looking at substantial compliance. We're looking at, can you put an in-home safety plan and the circumstances have been alleviated enough that that in-home safety plan is going to keep the kid safe. Note, this standard does not apply the 15 best interest factors in it. So while they applied between caregivers, nothing in 39.5224 incorporates best interest into a parent's reunification. Now, what if a different parent's currently caring for a child? Standard changes ever so slightly. And that is now we are looking at whether that reunification to go from, let's say, daddy to mommy would it endanger the safety, well-being of the child? And if reunification is the child's best interest. Please note that we can have a situation where dad was reunified and mom can be reunified too without moving the child completely away from the parent. We can have both reunified at different points in time. There has to be at least 6 months supervision for that. But the standard will come back to best interest if we do have the child currently residing with the parent. And then if we have to do a modification of placement after that point because the child returned to a parent and now has to come back home, the court has to consider very different factors. What led to the dependency? How long has the child been at home with the parent? What's that parent's protective capacity? Every one of these breakdowns is in 39.522. There's so many components of it. 522.2 is the general. We work our way through long-term caregivers, the parents, reunifying. Last but not least is an emergency modification of placement in 522.7, which is a new recent development. And so if we find ourselves in a situation where a caregiver requests the child immediately be removed, certain people can go pick up the child immediately, and that includes a case manager. But if we have to remove because of probable cause that a child's been abused, abandoned, or neglected, only an agent of the department or law enforcement can remove the child from the custody. Now, if we find ourselves in a posture where we have to do that modification of placement, the department has to file a motion if the child's not in licensed care. We do not have to file a motion if the child is in licensed care. There has to be a hearing that is done within 24 hours after the motion is filed, unless everybody agrees. Now, if not everybody agrees, if this is not a situation where a caregiver is asking for a child to be removed, then at the hearing, the court can hear all evidence, and this is like the equivalent of a shelter, all relevant material evidence to the extent of the probative value, even if it won't come in, i.e., the court can hear hearsay in determining whether there is probable cause. If there's no probable cause, the child goes back to the placement. Now, that doesn't preclude a party from going through the now what would be a planned placement change of filing a motion, proving best interest, try to secure an order that way. But if we find ourselves in a situation where instead the current caregiver admits there's a need for the change or there is probable cause, then the court enters an order on that emergency basis. Unless everybody agrees, we all have to come back for another hearing. So treat that almost like at our front end, we do a shelter and then we do a trial to secure the adjudication. This is, we'll do an emergency modification and then we will modify the placement only long-term after going through all of the steps of ensuring everybody has the fair opportunity to be heard under the best interest standards. Now, I can't have any training without on modification of placement without talking about transition plans. We have to do a transition plan before every single placement change. There is no exception under the law. And so that plan, we should be talking about how to incorporate all of the people involved so we can support the child. We can ensure the child has all their belongings, ensure the child has the ability to continue contact if that's what is best for the child afterwards. But we need to have transition plans. I've done a quick recap because we went through so many statutes, but on the screen are all the statutes that are involved in the modification of placement process in some way, as well as the original placement general considerations. So I appreciate you guys bearing with me as I went a little bit over in time. And I'll take whatever questions we can do.
Yeah, we still got a large group, Stephanie, and we have a lot of questions in the chat.
Okay.
So thank you for everyone for hanging on while I read them out and get Stephanie's answers. So the first one is we have a question about notice to the defense attorney of the MDT as it doesn't appear to be in the statute. Is there anything on that you can elaborate about?
And if a parent wants their attorney to attend, that attorney absolutely should be allowed to attend, and there should be no barrier to that. The parent is allowed to be supported. I cannot answer, however, why the legislature did not include them automatically. So I don't have a good answer for why they're not there, but they definitely can't be a participant in the process.
What if a parent files a modification of placement? Does an MDT have to take place before a change of placement or at all?
So, by the language of the statute, an MDT is required only if the Department of Children and Families or the CBC are the ones to conduct the placement change. So, that is the mandatory MDT. Can an MDT happen? It can happen. I would support an MDT happening because it can bring everybody together, have those really important conversations of what the child needs. But if a parent files the modification of placement, if the guardian files a modification of placement, if the attorney ad litem files a modification of placement, there is no mandate in Chapter 39 that there must be an MDT in conjunction with that.
If there is non-consensus, does the 5 business day period start running when the MDT staffing is concluded by the local CBC, or does it not start until the department responds to the CBC about the non-consensus?
So the 5 days runs from the notice from the facilitator after the staffing that there's a non-consensus. So the facilitator has a 48-hour window to notify the department and the court of the non-consensus. So if they notify in 1 hour later, that starts the clock, and the department has 5 business days from that point. If they notify the court and the department on hour 48, that's when the clock starts for the 5 business days. So it's tied to the facilitator notifying the department and the court of the non-consensus.
Perfect. We got several questions about child-parent bonding experts. Who
Yes.
qualifies? Are there any? Where do you find them?
So this is a question I get in every conversation about placement changes, and a question, frankly, I get from the legislature quite frequently about how this has been implemented and what happens. So the struggle we have with this is the language just says that they are to be an expert in the science of child and parent bonding, and it doesn't give the courts the description more so of what that means. So essentially, the court tries to do its best with those people that they know. I know that the Office of State Courts Administrator has tried to develop a list. It's an informal list. I believe that it's been shared informally with the dependency court judges and magistrates, but I've never seen that list myself. I've just instead been asked, do I have my own list? I do not have my own list because I too struggle with what exactly does it mean to be an expert in the science of child-parent bonding, because candidly, when we're using that, we're talking about caregiver bonds, and they might not be exactly the same as parent bonds either, because we might be talking about bonds between aunts and children or grandparents and children and all those things. So I have not developed my own list, and I hate that I can't answer a question straightforward here, but who qualifies as a child to parent bonding expert will be in the eye of that judge who appoints.
Do you need to complete an additional 6 months of supervision if the other parent is reunified at a separate time?
Yeah, so 39.521, I believe it's subsection 7, says that with each parent who is reunified, you have to complete a full 6-month supervision. So what that means is we're sitting here in January, we reunify with mom. Let's say mom is perfect and everything goes great. At the conclusion of June 30th, mom would be ready for the case to close, but dad gets reunified in March. We're going to have to keep the case open at least through September, because we have to give the father the opportunity to complete that supervisory period as well. So we have to complete 6 months per parent.
Okay. And this one is kind of a follow-up to one of our earlier questions,
Mhm.
where a parent is seeking reunification. If they would like an MDT, how would they go about setting that up?
My suggestion is to reach out to the case manager and ask that they contact the MDT facilitator. Each case management agency has their own MDT facilitators. And essentially explain that we know that this is not a mandatory one, but we can benefit, and here would be the goals of it. Here's what we would like to discuss as they go forward. There is the opportunity, especially if we're talking about parents being reunified, there is the ability for the department in our administrative code 65C that talks about that there can be MDTs for reunifications.
Great. And there's one more question in the chat. I believe it contemplates a situation where you have at shelter more than one family member
Yep.
being recommended for placement. So who would get priority for placement if both family members qualify and have an approved home study?
That's going to have us roll back to the best interest of the child. So we've got a situation of aunt and aunt. They're both equal relatives. They're both equal in priority. The court would have to necessarily look at the 15 best interest factors and start examining what the relationships are with each aunt to each child to understand. So it no longer becomes about priority. They have equal priority. Now it's about shifting to the best interest of the child to determine what is the best placement.
Okay. And another question popped up wanting to know, can a judge order an MDT staffing at a parent's request?
This is kind of a fun one. I've debated in my head. Can the judge order people to mediation? They absolutely can. Like there's the authority to order people to mediation. I don't know if it would be technically a separation of powers to conduct an MDT staffing in the way that it is designed by putting the burden on the department. But also, frankly, if the judge thinks that this will really help to do an MDT staffing, then we order it and we roll with the punches and we try to do the right thing for the child. What I think we have to get to for that first, though, is what's prompting that need for the MDT? What's going to really work in that? What's going to come out of that? What needs to be assessed in that? Because we see some really great productive MDTs, but also if everybody's going to it because everybody feels forced to go to it, I don't know that it's going to actually achieve the goals. So to think about it in a more productive way, outlining the goals, what should be considered would probably be more beneficial.
Awesome. That wraps up for the day. Thank you all so much for attending. Stephanie, are you open to sharing your PowerPoint?
Yeah, I
Okay,
could do the PDF version of all the slides and send them to you.
excellent. So if anyone who wants a copy of the PowerPoint wants to email me, I will drop my email into the chat and I will be happy to send you the PDF version of the PowerPoint. I've put both Rick and I have put the course number into the chat as well. It is 9619 if you haven't seen that. I hope everyone has a wonderful rest of the day. Our next training will be on residential treatment and psychotropic meds on February the 4th. So I hope to see you then. Have a good afternoon.